government officials. I call to order the meeting. It is the time and we have a quorum. I remind members, according to the rules of procedures, Rule 83, if you have any direct or indirect pecuniary interest concerning the discussion today, please disclose the nature of such interest before you speak. Now, following up on the previous meeting's matters, and also the government's written reply. Written replies have been submitted by the government. May I invite the administration to walk us through the reply? Kirk. Good morning, Chairman and members. Writing on the previous meeting, there were 3 matters to be clarified. Now, prior to the meeting, we have sent our written replies to the Secretariat. Here, I would like to highlight these 3 issues. First of all, concerning the text. In one of the interpretations, we have a term, proper printout. Now, for the Chinese translation, we use the term 合規列印本 for proper printout. Now, according to Cap 374D Road Traffic Ordinance and 374E, the regulation, for proper printout, the Chinese translation is 合規格列印本. At the same time, in Section 8 of 12U of 374D, we have used another translation that is 合規列印本 for the same term. So considering that Cap 374D is the latest provision, it is also compatible with the English word proper printout. That's why we used the translation 合規列印本. In any event, the term proper printout is already properly defined in the ordinance, so there should not be any discrepancies in terms of interpretation. Members, you may now press the button. Please continue, Kirk. Item 2. Concerning how to define Section 2(3), that is period throughout which a ride-hailing vehicle is in the course of providing ride-hailing passenger transport service. So the definition is from when the booking is made and until the service is completed. During that period, the ride-hailing vehicle would be defined as a vehicle providing ride-hailing passenger transport service. So that is in line with the definition in the amendments ordinance passed last year. Now, the app used by drivers on platforms are equipped with functions so that the drivers can update the platform on the status of the vehicle. For example, when they accept a fare and when the journey starts and when the journey finishes. So in the future, in the permits condition, we will require the platform to provide such functions on the app so that when the vehicles begin to accept the fare, the journey would start. And from that moment on, the vehicle would be defined as a vehicle providing ride-hailing transport service. The system of the platform must record the relevant time points clearly on the app. That also applies to advanced booking. Now, for those bookings, after receiving the booking, the platform would initially match the passenger with a driver intended to provide the service. Now, when the driver starts to receive the fare, then the driver can press a button. And that action is a spontaneous action on the part of the driver. So from that point on, the vehicle would be defined as a vehicle providing ride-hailing passenger transport service, and then the vehicle has to comply with the requirements. For example, displaying the permits at a suitable position. And also in the permit or license condition, we will specify that when the journey completes, the driver must click a button so that the platform would be notified of the timestamps. Now, thirdly, we thank members for their invaluable views. Now, besides the licensing conditions for the platform, there will also be practical guidelines to alert the drivers of the requirements. There will also be publicity and education to let the passengers know when the journey will begin to count. And finally, under what circumstances that a ride-hailing vehicle is required to display the ride-hailing vehicle certificate or designated identification marking at the specified position. Now, as we have mentioned, that's when the vehicle begins to provide ride-hailing passenger transport service. At that point, the driver has to display the marking for the benefits of law enforcement agencies and passengers. Now, once the drivers have clicked the button on the app to indicate that they have accepted the booking until the journey finished, during that period, that vehicle would be defined as providing ride-hailing passenger transport service, and the identification marking will have to be displayed. Thank you. Mr. Chen Xiu-Hong. Thank you, Chairman. I thank the administration for clarifying these points so that passengers as well as platforms and drivers can understand it better. Now, concerning the Chinese translation for proper printout, it is already clear. So the English term is the same, it's just the Chinese translation. Second, on how to define the period throughout which a ride-hailing vehicle is in the course of providing ride-hailing passenger transport service. So I would like to ask the question from the macro perspective, from when the journey begins and until the journey finishes. Now, if there is a private car, the driver is waiting for a fare, and during that period of waiting, the vehicle is not defined as a vehicle providing ride-hailing vehicle. I hope to clarify that, because when, in terms of insurance, the definition is very important. So when the driver is online but still waiting for a booking, it is not a vehicle providing ride-hailing vehicle service. Now, technically speaking, once the driver is online waiting for a fare, he is already providing the service. But you are now defining the period as when the driver accepts the booking. So if the driver is driving a vehicle, the vehicle is on the road, but the driver is still waiting for a booking, it's not a ride-hailing vehicle. But once the driver clicks the button and accepts a fare, so does it mean the driver has to park the vehicle and then find the identification mark and affix it onto the windscreens? Otherwise, if a fare is accepted and the mark is not displayed yet, will the law enforcement agencies stop the driver for failure to display the mark? So may I invite a response from the administration? Thank you. Mr. Yip, Mr. Kirk Yip. Thank you, Chairman, and thank you, Mr. Chen. But that depends on the actual situation. If the driver is waiting for the booking with the vehicle parked, then of course there would be time for the driver to affix the identification mark after accepting the fare. Now, according to in the practical guidelines I've mentioned, there will be suggestions for drivers on how to deal with the situation. If the car is already moving, A better approach is to affix the identification mark in advance during the wait, so that the drivers don't have to stop the car and affix the identification mark after accepting a fare. So for these particulars, we will specify them in the practical guidelines for the benefits of the platforms and the drivers. A follow-up question. Pardon me for being niche, because this is a new piece of law. In the mainland and other overseas jurisdictions, they don't have such a specific provision. Now, of course, as Kirk has explained, it would be most ideal if the driver affixes the identification mark once they are online. So if a driver accepts the fares and then stops the vehicle and affix the identification mark, now according to Section 2(3), period throughout which a ride-hailing vehicle is in the course of providing ride-hailing passenger transport service. So if a law enforcer accuses the driver of having the identification mark affixed but not providing a service, because technically the driver is just waiting for the fare, how would the situation be dealt with? Mr. Kirk? Yep. Thank you. According to the law, when the vehicles are providing the service, they have to display the mark. Beyond the period of service provision, for example, if the vehicle is being used for private purpose and the mark is affixed, that is not against the rule. Actually, the drivers can have the identification mark affixed to the windscreen all the time. But the law is clear that when the vehicle is providing such service, the mark must be displayed. Chairman, I would like to clarify one point. Displaying the designated identification marking. When it is lawful or legal to display the mark. Now, of course, there is no dispute if the vehicle is providing the service. However, during the period when the driver is online and still waiting for a fare, does he have to display the mark? Or is it okay for him to display the mark? I think Mr. Chan Siew-Hong has been repeating his question. The main concern is whether the driver has to display the mark once the driver is online. Now, it seems that the government's version is that the driver only needs to display the mark once a fare has been accepted. So is it okay for the driver to display the mark during the wait online? Allow me to clarify this. The statutory requirement is that during the period or once the driver has clicked the button to accept a fare from the platform, and then when the driver is setting out to the pickup point, from that point on, the vehicle is defined as a vehicle providing the service, so they will have to affix the mark. However, when the driver is online and still waiting for a fare, there is no requirement for the driver to display the mark. But it is okay for the driver to display the mark.
I need the government to clarify this in black and white. Because in the laws, there is no regulation saying that the driver should or should not display the identification mark when they have not picked up the passenger. This is very confusing for the drivers. They don't know if they need to display the mark when they come online, or are they only required to display the mark after accepting the booking? The government said that is easier for drivers to display the identification mark at all times. What happens when they're driving their family members? Can they display the mark? As long as they have not accepted the booking from the platform, then they are not offering service. Can they display the identification mark at the windscreen? Would that be a problem? I think that the government needs to further clarify it. If you have any further details, please write to us. Thank you. Mr. Chen's understanding is correct. Once the driver comes online with a platform, when they're using the private car to drive their family members without offering ride-hailing service, it's not illegal for them to display the identification mark. We'll set that out in the practical guide so that there will not be any form of misunderstanding. Please write to us. Mr. Lam Wai-kong. Thank you. My question is similar to that of Mr. Chen Xiehong. Some ride-hailing drivers may plan to work on a particular day and they display the identification mark before they depart, and they will come online with the platform. When a driver intends to offer ride-hailing service, should they already display the identification mark? Second, if I display the identification mark on my vehicle, does that mean that I am already offering ride-hailing service? When will my vehicle be regulated by the ride-hailing service regulations? Because for a P license holder, they have certain restrictions. Say, for example, they should not drive faster than 7 km per hour. What happens when I come across law enforcement agencies? If the ride-hailing drivers display the identification mark at all times and when they are just driving their family members, will they be regulated by the ride-hailing service regulations? Mr. Yip, thank you. Our definition in the law is very clear. When the driver is offering ride-hailing transport service, they need to display the identification mark. Now, in terms of law enforcement, when police take action, when they come across a driver offering ride-hailing service with a passenger at the passenger seat without displaying the identification mark, then they are breaching the law. What happens when they're displaying the mark while carrying or driving their family members? Some drivers may display the identification mark at all times just to make it more convenient for their work. This is not illegal. We need to make sure that drivers display the mark when they're offering service. Our laws is that when driver offers a ride-hailing service, they need to display the identification mark in their vehicles. The Secretary. Let me summarize our response. We will give members a written reply. In the practice guide, we're going to set out many different scenarios to make it more convenient for drivers and law enforcement agencies to enforce the law. I have 3 points to make. First, our requirement is very clear. When a driver convert their private cars into ride-hailing service vehicles, there are two important junctures. That is when the time they start offering service and when the time they stop offering service. During this period, they need to display the identification mark in accordance with the law. If they don't do that, they break the regulations. Second, before offering ride-hailing service or after offering ride-hailing service, the drivers sometimes may opt to display the identification mark just to make it more convenient, taking into account road safety concerns and actual operation. Should we ask the drivers to stop their vehicle to display the identification mark after they accept the booking? As replied by Mr. Yip, drivers can display the mark before or after they offer ride-hailing service if they expect to offer service within that day. It's not illegal for driver to display their identification mark even when they're not offering ride-hailing service. Third, as mentioned by Mr. Lim Wai-kong, when drivers are not offering ride-hailing service and display the identification mark, will there be any form of confusion? Is this an abuse of the regulation or ride-hailing service? Well, the identification mark is not the only evidence the police look at when they assess whether a driver is breaching the law. We can look at the application of the platform operator because it's connected with that of the transport department. So through technology and the systems, we will collect evidence to see if the drivers is offering service legally or illegally. The police or the law enforcement agencies will not just rely on the identification mark. We're going to give members more details in a written reply. We're also going to include that in our practical guide. Mr. Cha Chiu-tong. The administration has given us a very clear reply. As they are formulating a practical guide, I have some further questions. The vehicle will only be considered as offering service after the driver has accepted the booking. This answer is very much clear. Drivers can display the identification mark regardless of whether they are offering ride-hailing service. Will there be such a possibility that drivers take passengers on the street, or they take ride-hailing on the street? How can we combat such a possibility? Second, regarding the identification mark, we ask the drivers to install a electronic device at the front windscreen in such a way that as long as the driver accepts a booking, then the operator control the electronic device to light it up, like the light in front of the taxi. When the journey is completed, the platform operator can turn off the electronic device at the front of the ride-hailing service vehicles. I think that this addresses the problem because it would be very inconvenient for us to ask the drivers to display the identification mark after accepting the booking because they may have to park the car at the roadside. I think that the Secretary can consider this suggestion. Thank you. Thank you, Mr. Chao Shu-chong, for the suggestion. Mr. Chan Shu-hong and Mr. Lam Wai-kong have given us some suggestions, but we'll look into them. When we formulate our practical guide and when we talk to the platforms on identification mark, we will consider all these recommendations. I hope that the administration will give us a written reply. It may be inconvenient for us to ask the drivers to display the identification mark after they accept the booking, and we are also worried about ride-hailing service drivers accepting street hailing if they can display the identification mark at all time. and there may be confusion when drivers display the identification mark when they're driving just their family members or friends. I hope that you will clarify all these in your written reply. Let's continue. Percy, please. Let's continue with the clause-by-clause examination. We are at part 2 of the regulation. That's about the provisions on the ride-hailing service platforms. Regulation 3. Fees relating to application for and issue of ride-hailing service licenses. According to Regulation 3, the applicant need to pay the prescribed fee. That's $16,200. That's set out in the schedule. The annual fee need to be paid when the license is granted, and for the subsequent annual fee, they will be payable on or before the date specified in the license conditions. The fee per year is $1.2 million. Any questions? No. Regulation 4. Ride-hailing service license may be in paper form or in form of an electronic record. The ride-hailing service license must state the validity period, the name of the licensees, the license conditions, so on and so forth. Regulation 5. This is the validity period of ride-hailing service license, which is 5 years max. Regulation 6. That's the extension of validity period of ride-hailing service licenses. According to Regulation 6, the licensee can apply for extension of the license to the commissioner. Again, the licensee must pay $16,250, and the extension period must not exceed 5 years, and the extension can be done more than once. The applicant or the commissioner will issue a written confirmation to the licensee, and if the commissioner refuses the license, the notice must state the reasons for the refusal. Annual fee, again, during the extension period is $1.2 million. It should be payable on or before the date specified in the license conditions. Mr. Chris Yip, does it mean that for commissioner may not grant an extension of 5 years, and under what circumstances will the commissioner not extend the license for 5 years? According to Subregulation 6, it is said that if the commissioner refuses the application, they will state the reasons. Will the commissioner give the reason to the applicant for why they do not extend the license for 5 years? It says in the regulation that the extension period must not exceed 5 years, and commissioner has the power to refuse to extend the license for 5 years. They can extend it for less than that period. The commissioner will look at the performance of the platform to see if they're confident in the platform operator. In the notice sent to the applicant, the commissioner can explain to them the considerations they take into account. So you will inform the applicant if they don't extend the license for 5 years. We may inform the applicant about the reasons. Well, if the vehicle license period validity is less than 3 years, then they will not extend it for 5 years. Well, this is about platform, is it not? Yes. Is there any objective factors the commissioner will consider when they look at the extension or renewal applications?
处长。
Commissioner, Chairman, we will continue to monitor the service performance of the platform. And one of the requirements is for the platform to maintain effective services. So we would monitor the number of vehicles online, the number of fares or bookings accepted or completed, and also the due diligence performance. So there will be quantifiable data for us to assess whether the performance is satisfactory for the first 5 years. And then we would consider whether we would extend the license for 5 years' time and whether there is a plan to make improvements. So for these cases, we would extend the renewal for, say, 3 years and continue to monitor the situation. So is my understanding correct that if during the first 5 years of operation there are no non-compliances according to the data, then you would extend the license for 5 years' time? Secretary. Thank you, Mr. Crisip. Now, according to the power given to the Commissioner for renewal, the maximum extension is 5 years' time. And the Commissioner has discretion to grant a renewal for less than 5 years' time. That's completely within the power of the Commissioner. That is the same practice for the renewal arrangements for other franchised services, including ferries and franchised bus. The purpose is to allow the Commissioner some flexibility to review the performance of the platform. Now, the cases listed by the Commissioner are some examples. In fact, during the 5 years period, there would be a midterm review to assess the performance of the platform. So there will be timely feedback to the platform. And then by the end of the 5-year period, the Commissioner will have the discretion to extend the license for a number of years. And the reasons for doing so would be given to the platform as well. The mechanism is fair and transparent. Thank you. Dr. Thomas So. Thank you, Chairman. Same question with Mr. Chris Ip. Section 6, bracket 6. If the Commissioner refuses the application, reasons have to be given. So that's about whether an extension is granted to the licensee. So would you give the licensee a reasonable expectation that there is a list of conditions on the license, for example, the service performance and other things? So can the licensee reasonably expect that you would only consider the factors listed on the license, but not other policy concerns? For example, at one point you think that 5 licensees are too many and you would like to reduce the number of licensees. The platforms would have invested a large amount of resources into the license. So if the Secretary tells us that the future is uncertain, then it would be not ideal for investors. Against the investors expect that the government would grant them an extension if all the conditions on the license are fulfilled. Now, Section 4(3)(b), the period within which the relevant ride-hailing service licensee may apply for an extension of the validity period of the license. I don't quite follow the Chinese translation of that provision. Secretary. Thank you, Chairman. I will supplement on the first point, and I will defer to my team for the second question. Now, Dr. So's observation is correct. The power to grant and extend the license is vested with the Commissioner. Now, on making a decision, the notice of the reasons would be given to the licensees. This will give the licensees a reasonable expectation. Normally speaking, we would assess the performance of the platform according to the license conditions. However, if there are policy changes or changes in actual social circumstances, then we would keep communication with the licensees so as to ensure the sustainability of their services as well as their investments. We emphasize that this is something new, and we encourage more candidates to join the industry. We would like to attract quality platforms to come to Hong Kong to provide such services. Thank you, Chairman, and thank you, Member. Now, Section 4, Subsection 3 is about the award. Information must be specified on the license. Now, Part B is about the period within which the ride-hailing service licensee may apply for an extension of the validity period. So the meaning is when the licensee can apply for the license. Mr. Eric Yim, thank you. Deputy Chairman, I have a suggestion. Section 6, extension of validity period of ride-hailing service licenses, subsection 2 and 3. Can we change the order around? We should first state that the validity period of a ride-hailing service license may be extended under subsection 1 more than once, and then we should say that the extension period must not exceed 5 years. Now, according to the existing order of the provisions, it seems to give an impression that at most the platform can operate for 10 years in total. So if we change the order around, it will make more sense. If we say the extension period must not exceed 5 years first, then people would get the first impression that you can only get one extension at most. Secretary, thank you, Mr. Eric Yim, for your question. Now, your point is valid. During the drafting of the law, those two considerations go in parallel, but we will consider your suggestion. We think the existing order of the provisions can also achieve the same effect. Mr. Chen Siu-hung. Thank you, Deputy Chairman. Now, taking all the sections together, now the platform fee, license fee is $1.2 million per year, and the platform can apply for an extension for no more than 5 years. So is my understanding correct that after the first year, if the platform has been granted a license period of 5 years, do the platforms have to pay the $1.2 million in each year or in one go for all 5 years? Now, if the validity period is 5 years, will you require the platform to pay the fee in one go or annually? Now, whichever your answer is, say if a platform has operated for 6 months, then for whatever reason they surrender the license, will the license fee for the remaining 6 months be reimbursed to the platforms? Thank you. Secretary, Mr. Kirk Ip. Thank you, Chen. Thank you, Mr. Chen. Subsection 3, brackets 2 and 3, we have specified the arrangements for paying the annual fee. Now, the first year's license fee has to be paid before the license is granted by the Commissioner. Subsequently, for the $1.2 million annual fee, we will set a date on the license, and the annual fee has to be paid by that date. Second question, if the platform has paid the fee but wants to surrender the license, then the remaining license fee will not be reimbursed. So will these be specified in the future guidelines? Now, $1.2 million are not a lot, but we have to make sure that the arrangement is clear for the platforms to understand. Secretary, Mr. Ip, thank you for your suggestion. We will specify the condition clearly when the platforms apply for the license, and we will also make it known to the platforms that in these situations, the license fees will not be reimbursed. Now, Mr. Crisip said that there would be a date specified on the license by which the annual fee must be paid. So is that the government's intent that the annual fee has to be paid annually? So even though a 5-year license period is granted, the platform will have to pay the fee year by year. Mr. Michael Lee. Most of my questions have been covered by Mr. Chen. Sections 4 to 6 are about the continuity of the license. Section 4B, it says that the company can apply for an extension at any time during the period of validity. So what about surrendering the license? Is there requirements for the platform to notify the department, say 3 months ahead? I'm worried that there may be more than one platforms surrendering the license because of poor business. That's the worst case scenario, of course. Thank you, Mr. Michael Lee, for your question. Now, under Section 4, we have specified, we will specify on the license under what conditions or during which period of time the platform can apply for an extension. Actually, we would gauge the intent of the licensee in advance, say 1 year before the expiry of the license. Now, if the licensee does not intend to continue to apply for the license, then we will make arrangements for the drivers and vehicles on the platform. So we will gauge the view of the platforms as soon as possible. Thank you. I hope that will be at least 3 months' time for the platform to prepare. You should gauge the views way ahead and also gauge the feedback of the passengers. And also sort out the transitional arrangements for the drivers and vehicles on the platforms. Thank you.
This is important because if there is prepayment, then we need time for the government to arrange for refund. My apologies, Chairman. I have questions that is policy related. When it comes to the ride-hailing service regulation, I'd like the government to further clarify all these. We already discussed the definition of ride-hailing platform. The regulation will regulate all ride-hailing service. The platform, if they offer ride-hailing public transport service, they also need to turn in the relevant data to the government. There are some platforms that offer not just a private ride-hailing service. They allow public vehicles to offer service through the internet. Will these platforms need to apply for a platform license under the regulation? I hope that government will further clarify it. Are you asking about submission of data? More than that, I also like to ask if these platforms need to apply for a license. Thank you. When we scrutinized the principal ordinance, we already discussed this. If a platform or an operator allow public transport vehicles to offer pre-booked service. Say, for example, taxis have a public transport vehicles. They can offer ride-hailing service by nature. If operators offer just ride-hailing service for taxis, they do not need to apply for a license under the regulation. Thank you. Let's continue. Now we're at Regulation 7. That's about variation of license conditions and the procedures. In the amendment ordinance passed last year under Section 55J, it is said that the Commissioner can impose on the license any conditions they consider appropriate. According to Regulation 7, during the validity period of the license, the Commissioner can vary, cancel, and impose any additional conditions. If the Commissioner decides to take such an action, they need to consult the licensees and explain to them the reasoning as well as the validity period of the additional licensing conditions. The licensee can object to the Commissioner's taking of the action by written notice. If the Commissioner eventually still decides to take an action, they need to explain to the licensees the reasoning behind the action and the effectiveness of the decision need to be 21 days before the conditions is effective, such that the applicant can take action in the tribunal. So the Commissioner will only explain the reasons behind the action when the licensees object to the decision. Would it be easier for the Commissioner to state the reasons on the notice if they decide to cancel or vary the conditions? Well, if the licensee object to the action, they can make application to the Transport Tribunal. This is such that the licensee know why the Commissioner took the action. My question is this: why does the Commissioner not state the reason regardless of whether there is any objection? The Commissioner can explain the reasons behind the action when they take action. But in terms of statutory requirement, we want to state very clearly in the laws that when the licensees object to the decision, the Commissioner need to state the reasons such that when the licensee is aggrieved by the decision, they can go to the tribunal based on the reasoning. I think Mr. Ip is referring to Subregulation 4. It is said that if the Commissioner decides to take an action, they need to give written notice of the decision to the ride-hailing service licensee. Thank you, Chairman. When the Commissioner issue the written notice, they can state the reasoning. The administration merely say that they can, but it's not a must. It's not a must according to the laws, but I believe that when the Commissioner make a decision, they will state very clearly in the notice the reasoning. Chairman, I don't think that this is good enough. There may be misunderstanding. I just wonder if the Commissioner will state the reasons or not. Well, in the Subregulation 2, it is said that the Commissioner must consult the licensee, so I believe that the licensee would be aware of the reasoning. Thank you, Chairman. Your understanding is very much correct. Any follow-up questions? If not, Mr. Chan Xiu-hong. Thank you. I believe that in the scenario described by Mr. Ip exists in other regulations. When the administration thinks that there is a need to impose additional or vary or cancel any licensing conditions, they will consult the licensees. If the licensee is aggrieved by the decision, they can launch a judicial review or go through other legal procedures. I have a question regarding Regulation 7. It's about variation of license conditions. Under 1B, it is said the commissioner can vary any of the license conditions. So what considerations will the commissioner take into account before they decide to vary the license conditions, say, for example, a public interest or road safety? According to CAP 349, Section 12E, there is under also Section 108, Section 62D, CAP 107, Section 7C, they state very clearly the considerations the authority will take into account before varying any license conditions. The nature of this regulation may be different, but I hope that the administration will explain why the regulation is set out in such a way. Thank you. Secretary. Let me answer Mr. Chan's first question first, and then I will address Mr. Ip's comment. Regulation 7.1b, it is said that the commissioner can vary any of the license conditions. We want to reserve for flexibility for the commissioner, that is the authority. We don't want to restrict, to put too much restrictions, because public transport is about livelihood. It's a brand new piece of regulation. We don't want to set any preconditions to the power of the commissioner. When the commissioner think that there is a need to vary any of the license conditions, they will keep in close communication with not just one platform, perhaps all of the platforms. The commissioner will take into account many different considerations, say, for example, passenger safety, road safety. I believe that the commissioner will communicate very clearly to the licensees before they decide to vary any of the license conditions. Second, in reply to Mr. Ip's question, in 7(4), it is said that if the commissioner decides to take an action, the commissioner must give written notice of the decision to the ride-hailing service licensee. When a regulator makes any decision, they will explain the reasoning behind it to the regulatees. In Regulation 6A, it is said that the notice of the decision must state the reasons for the decision. We state here that the commissioner needs to state the reasons for the decision behind the notice is because an action is involved. I thank Mr. Ip for noticing such a detail. Thank you. Mr. Lam Wai Kong. If the platform objects to the action of the commissioner, they can go to the Transport Tribunal. If the commissioner suspends the operation of the platform, can the platform still operate legally? Second, if the commissioner suspends the platform, will they announce such a decision to the public so that everyone knows that there is such a decision in place? Or will the announcement be made after the litigation period or hearing period? If after the litigation process, if the commissioners decide still to cancel the license conditions, will the licensees still be able to go through other legal procedures? Thank you for the question. Regulation 7 is about license conditions and their variation. It's not about the validity of the license itself. Regulation 7 is about the power the commissioner have to impose additional license conditions. It will not affect the validity or effectiveness of the license. As mentioned in the principal ordinance, if the commissioner finds the license breaching the regulations, and they can suspend the license. The licensees can overturn the relevant decision by going to the transport tribunal. The decision of the commissioner will not take effect immediately. The transport tribunal will have the final say. We'll go to that later on. Mr. Jonathan Lampert. Thank you. The license is generally valid for 5 years. We hope that there will be more platforms coming to our market by having this piece of regulation. Platform operators need to make huge investment before they can operate on the market. I hope that the government will come up with a clearer set of guidelines. I know that the government wants to be more flexible, but investors need clarity and certainties. Under what circumstances will the commissioner take any action set out in Regulation 7? And this is helpful in attracting investment to Hong Kong. Secretary, thank you. We encourage platform economy, and we want more investors to come. Second, supervision and regulation are equally important. The commissioner needs to monitor the performance of the platforms. We're not going to take any action or make any decision without informing the platforms in any way. We will always keep in close liaison with the platforms, and when we make any decision, we'll before that try to make sure that the platforms is up to par. When the commissioner make a decision, they have to go through certain steps, and in the laws it is clearly stated that the licensees can make an appeal when they are aggrieved by any decision. As we formulate the license conditions, we will invite the licensees to give their suggestions. Eventually, the authority will have the power to amend any conditions. Thank you.
陳少雄議員，
多謝主席。就
Mr. Chan Siu-Hong, Section 7, Brackets 2. Before the Commissioner takes an action under subsection 1, the Commissioner must consult the ride-hailing service licensee. Now, the Secretary said that the governments would like to reserve some flexibility. That's understandable. However, that would reduce the certainty for potential platform operators. So a balance must be struck. Now, I've noticed that the legal advisor has submitted a question to the government, and in reply, the administration said that it would like to reserve flexibility, and that administrative means will be used. For example, the Commissioner would issue a notice to the platforms. So what's the view of the legal advisor on this? Thank you, Chair. We don't have any follow-up questions on the government's reply on whether this method or this approach is appropriate. We will leave it to the members. Thank you, legal advisor. That's exactly the concerns we have. Should we give maximum flexibility to the Commissioner while reserving some flexibility? We have to strike a balance and not to give the executive branch or the departments too much power. Otherwise, it would lead to judicial review or other debates in society. As I've mentioned, the investment is much more than the $1.2 million annual fee. There will be a lot of investments, including hiring employees in Hong Kong. So the government should make clear all the requirements and the government's thinking process in the practice guidelines and so on. Thank you. Now, in our written reply to the legal advisor's questions, the thinking process is the same as the oral answers we have given just now. That is to ensure sustainable growth of the industry while meeting the daily commuting needs of the passengers. There will be effective mechanisms to ensure that there is sufficient communication with the platforms. And I believe that our proposals have already struck a balance. Please continue. Thank you, Chairman. We are now at Section 8 of the regulation. Brackets 1 and 2, the Commissioner may exempt a ride-hailing service licensee from complying with any provision of the ordinance that applies to the licensee or the licensee's licensed platform. When granting the exemption, the Commissioner may impose any conditions they consider appropriate. Subsection 3, the Commissioner may, at any time during the validity period of a ride-hailing service license, take one or more of the following actions, that is to revoke an exemption granted or impose on the exemption any conditions, or vary any exemption conditions, or cancel these conditions. However, before taking such action, the Commissioner has to consult the licensee and give the licensee a notice. Mr. Chan Siu-Hung, now I agree that we need to give the Commissioner some flexibility to vary the exemption conditions or deal with other matters. Now we have some concern over the exemptions granted, on the other hand. Now, if we grant an exemption to a certain platform from compliance with certain conditions, would it be against public justice or the principle of fairness? Is it necessary to make specific provisions on exemption? Because granting exemption is a great power. Mr. Kirk Ip. Thank you, Mr. Chen. Section 7 and 8, the policy intents are similar. In regulating the service of the ride-hailing industry, we are still uncertain about the future growth of the market, so that's why we want to reserve some flexibility to ensure that we can achieve regulation while providing a safe means of transport for the passengers. So by flexibility, we will reserve flexibility in the licensing conditions. The same applies to Section 8. Now, under the taxi fleet mechanism, there are similar conditions in place. Based on the actual situation, the Commissioner may grant an exemption concerning specific platforms based on their unique operational model. Mr. Chen Sihong, thank you. That goes back to the principle mentioned by the Secretary. So we have to trust the administration that in exercising these power, the government would have gone through a very rigorous thinking process. Now, during the scrutiny of the principal ordinance, we have mentioned our concerns that with so many platforms operating in Hong Kong, there may be an involution, there may be vicious competition against each other, and it may lead to the situation of an oligarchy. And some platforms may treat their drivers poorly in terms of profit sharing. So if there are unfair practice, the government may consider using these power to discourage such practices. Thank you. This is also our thinking process as well. Mr. Eric Yim, thank you. Let me follow up on Mr. Chen Siu-hong's concern. An exemption can be granted to any platform from compliance with the licensing conditions, and that's a great power. Section 7, I agree that the Commissioner can impose variations on the licensing conditions. Now, however, can the Commissioner exempt the platform from paying the full annual fee of $1.2 million and reduce the amounts to $1 million? Does the Commissioner have the power? And also, can the Commissioner grant an exemption on the maximum extension period of the license to more than 5 years? Thank you. That's the question concerning the business model of the platforms. Thank you. Now, as we have said, the purpose of the exemption is to make adjustments to the market's development. So the Commissioner would act reasonably and consider the interests of the public as well as our transport policies to ensure that there is a balance. If these powers are invoked, the Commissioner will have to give very clear reasons behind the decisions. Secretary, Mr. Kirk Ip has mentioned our justifications. Now, concerning the license fee mentioned by Mr. Eric Yim, there will be no exemption granted on payments of the license fee. It is not subject for exemption or variation. Dr. Thomas So, thank you. Section 7 and 8 has given great powers to the Commissioner. So there is not a limited scope concerning the exemption. So would the government consider setting a scope for the exemption? And also the factors to be considered before the powers are exercised. In granting an exemption, it may not necessarily be beneficial to the platform or the industry as a whole. Now, after granting exemption, it may lower the cost of the platform's operation, and it may be unfair to other licensees. So according to Section 8, other parties or other licensees have the right to raise an objection towards the exemption granted to another licensee. Now, an exemption granted to just one platform may cause other licensees or other platforms to feel that they are being treated unfairly, so we should give the other licensees the right to raise an objection or apply for a review. Secretary, thank you. On that, we will provide written reply after the meeting. We will give you real examples in the past under the taxi fleet mechanism and other public transport services. According to the situation, we have granted exemption on niche conditions on the licenses, and we can provide these information to members for reference. Mr. Lam Wai Kwong, I also share other members' views that the power of exemption is too great. Should we remove these sections altogether to avoid disputes? Now, if exemption can be granted on various aspects of the license, then besides what Dr. Thomas So suggested, that other stakeholders can raise an objection, what about the taxi industry? If the taxi industry thinks the exemptions are too unfair, can all the other stakeholders in the point-to-point passenger transport service industry raise an objection to the exemption? Secretary, as I've mentioned, the Transport Department, as the licensing authority, the Commissioner would have the power to grant an exemption to the licensing conditions, and that's not unique to the ride-hailing vehicle licensing mechanism. In dealing with other licensees in other industry like taxi fleet and franchise bus services, there are similar arrangements, and it's not as great a power as described by members. Now, actually, the power to grant exemption goes hand in hand with the power to vary the license conditions and to grant or revoke the license. So we will provide a supplementary answer after the meeting.
咁理解咧，就係因為網
Secretary, is my understanding correct? There are many different types of service offered by ride-hailing service platforms. The Secretary need to have regards to the nature of the business before imposing different license conditions on different platforms, and that is why you have an exemption arrangement. That is correct, Mr. Chao Chi-chung. The administration said that they need power to exempt certain licensees from complying with some provisions in the ordinance. I fully understand that arrangement. I'd like to follow up on Mr. Yim's questions on platform fees. The Secretary said that they will not exempt annual fees from any licensees, but under Regulation A(1), it is said that the Commissioner may exempt licensee from complying with any provision of the ordinance that applies to the licensee or the licensee's licensed platform. The requirement to pay management fee is one of the provisions in the regulation. Can the Commissioner exempt that? The Secretary already answered it. Then it's problematic for you to write Regulation A(1) in such a way. Secretary. We need to now look at the schedule to the regulation about the annual fees of the licenses. We set out the amount of the fees in the schedule. That much is very clear. We will further clarify it in a written reply. Thank you. Members have put many questions. I hope that the administration will address them in the written reply. If there's no further questions, please proceed. Thank you. Now we're at Section 9 of the regulation, updating particulars stated in ride-hailing service licenses. If the license is issued in paper form, the Commissioner must not grant the application unless the applicant delivers the license to the Commissioner, so that the Commissioner can update the particulars on the license. Legal advisors have questions about Section 9(1) about the definition of particulars. By particulars stated in the license, it is about the details to be set out on the license according to Regulation 4(3). This allows the Commissioner to take action when provisions in the regulations are amended. Say, for example, if the Commissioner impose additional license conditions according to Regulation 7(1) or extend the validity periods of the license according to Regulation 6(1), then the Commissioner can update the particulars in the license to reflect the change. If the licensee change their names, they can apply to the Commissioner to update the particulars, that is, the name stated in the license. To put it clearly, Section 9(1) allows the Commissioner to update the license. If the Commissioner wants to change the license conditions, they have to act in accordance with Regulation 7 about driver's permits and platform licenses. We have similar conditions or provisions allowing the Commissioner to update the particulars. Mr. Shan Shihong, thank you. According to Section 9, it says the Commissioner can update the particulars in the license. By particulars, the administration means the content set out in Section 4(3). And the Commissioner may update any such particulars. In Section 9(2), it says if the ride-hailing service license is issued in paper form, so on and so forth. My understanding is that the administration wants to remain flexible. In fact, it is said in the policy address that the SAR government wants to go digital. We are now, for example, digitalizing a driver's license. For this new ride-hailing service license, I believe that all of their applications are digital. Why do you retain the paper form of license? Why should we not go full digital? Why do you include such a provisions on issuing license in paper form, and the government cannot grant the application of update unless the applicant delivers the paper form license to the Commissioner? I wonder why that is. Thank you. Mr. Yip? Thank you. Mr. Chan's understanding of the word particular in section 9 bracket 1 is correct. It's the same as those set out in regulation 4 bracket 3. When we regulate ride-hailing service, we're going to introduce a digital permit system. For vehicle permit, driver permit, they will be issued digitally or electronically. We just want to remain flexible when we formulate Section 9 bracket 2. For the taxi fleet regime, we issue also licenses in electronic format. When the government is promoting digital and smart governance, we will consider issuing permits and license in digital format. Chairman, my understanding is that they will mostly issue permits and license digitally. They just want to remain flexible by including Section 9 bracket 2. Secretary, thank you. We are determined to go digital. However, at this stage, we want to keep Section 9 bracket 2 to reserve room for flexibility. But that will not undermine our determination or progress in going digital with our licenses and permits. Please proceed. Thank you. We're at Regulation 10. Delivery of paper form ride-hailing service licenses in certain circumstances. If the paper form license need to be updated, then the licensee need to, within 72 hours after the date on which the license would have expired, send the license to the commissioner. If anyone violates the regulation, then they will be penalized with a fine at $2,000. The commissioner need to update the particulars after receiving the paper form license. If the license is suspended, then the commissioner needs to keep the license, and if the license is revoked, then the relevant action need to be recorded. Mr. Thomaso, thank you. If the company does not deliver the license to the commissioner within a certain number of hours, then they will be fined. Under certain circumstances, the licensee need to deliver paper form license to the commissioner. You set out certain scenarios in Section 11. If the licensee does not comply with the requirement, then they will be considered having broken the laws. Will the administration remind the licensee that they need to submit their license to the commissioner? Otherwise, they'll be breaking the law. Thank you. All the scenarios set out in Section 10 bracket 1 will be informed in written form by the commissioner to the platform operator. Thank you. Now we've come to Section 11. If a ride-hailing service license issued in paper form is lost, destroyed, defaced, or damaged, the licensee may apply to the commissioner for a duplicate. If the commissioner is satisfied with the reasoning, then after the licensee pay the $1,510 fees, they will be issued a duplicate license. The legal advisor wrote to us asking how long the issuance of duplicate license will take, and will the destroyed or defaced license be considered valid. Well, as long as the application meets the requirement, the commissioner or the transport department will issue the duplicate in a few working days. even when the license is destroyed or lost, the license will still be considered effective. The operator can still do their business legally. The arrangement is the same for taxi fleet license. Any questions from the legal advisor? No. Mr. Chan Xiu-Hong. Thank you. For paper form license and duplicates, when law enforcement agencies arrive at the office of the platform company, they may need to collect evidence. If they have a printout, if they have the paper form license, then they can collect it, and the platform will be considered doing business legally. How can the law enforcement agencies know whether a license is valid or not? Will they have to call the transport department? The same goes for a digital driving license. When law enforcement agencies ask the driver to show their license, then they can show their license on their IM Smart application. And the QR code of the license update regularly. How can the law enforcement agencies make sure that the license is valid? Will they have to call the TD? Who will take the question? Mr. Yip. Thank you. If the platform license is issued digitally, the transport department will keep a clear record as to when the digital license is issued. When LEA take enforcement action, they can confirm and verify the information with the transport department to see if the digital license held by the platform is legal. I thank Mr. Chan for the question. Last year, when we passed the regulations on digital driving license, we addressed the same question. The transport department and the platform company can work together. On the arrangement of how the real-time generated digital license will be displayed such that no one can show a screenshot license. The Secretary. Will the government develop a brand new system to display licenses, display a few licenses that are granted to just a few licensed companies? Would that be a waste of resources? The Commissioner for Transport. Thank you. We are determined to go full digital. In the later part of the regulation, we'll look at the driver's permits, the vehicle permits, and how they will be issued digitally. We understand that we're not going to have thousands of platforms. If we are to build a dedicated system for just a few platforms that are to be granted license, then that may be a waste of resources. Mr. Chan Xiu-Hong asked about law enforcement. When LEA arrives at the office, it may be easier for them to collect evidence. We'll go back and look into it. As we go full digital, maybe at the outset we will consider issuing paper form license.
跟進呢一點嘅，主席係好英明嘅。頭先
Thank you, Chairman. I would like to follow up on one point. I agreed with the administration reply that we have very few platforms. Then it is not wise to spend so much money on developing a system just for them. However, we have the business version of I'm Smart. Law enforcement agents can simply turn on the page on the business version of I'm Smart and find the information to enforce the law. Thank you, Chairman. We are now at section 12 of the regulation. This is about keeping of records. Now, the principal ordinance, or the amendment ordinance passed last year, have added section 55L in the road traffic ordinance to require the licensees to provide service information through the platform, keep the record, and provide the record to the commissioner on request. So, section 12 bracket 2 sets out the types of records to be kept by the ride-hailing service licensee. Bracket A is about the vehicle's information, including the number of licensee's platform vehicles at the time specified in the license conditions, the vehicle permit number, registration mark, and passenger seating capacity of the vehicles, and the duration for those vehicles providing the ride-hailing passenger transport service. In other words, the working hours of the drivers. Part B, the number of licensees' platform drivers, the name and driving permit number of the drivers, as well as the duration for which the drivers have been providing the service. Now, according to the legal advisor's letter, they would like to clarify the definition for the term access. Now, according to the Oxford Dictionary, it refers to an access to any internet network or intranet network. So in this context, it applies to the number of online hours of the drivers only, and we don't think we need to specifically define the term access. Now, Part C, that include the information on journeys, that is the number of platform bookings, the number of journeys completed, and number of journeys cancelled, the amount of fares charged, the interval between the time at which the platform booking is made and the time at which the vehicle arrives, as well as complaints and traffic accidents information. Now, Part D, besides the above information, the licensee must also maintain other information specified in the license conditions. Now, according to paragraph 5B of the legal advisor's letter, they would like to inquire about the examples of other information. Now, with the developments of the service and the technology, we may require other types of record from the platform. That's why we think it is necessary to add clause D to maintain some flexibility for the commissioner to require other information other than those required by the license for regulatory purpose. Now, the legal advisor also asked about the meaning of the period specified in ABC brackets 1. Now, during the validity period of the license, we require the platform to maintain record concerning the number of different drivers and vehicles for us to regulate the service. Now, subsection 2 and subsection 3. Subsection 2 applies to ride-hailing services provided by the platform, and subsection 3 applies to taxi online booking services provided by the platform. So in case the platform provides taxi hailing service on the platform, they will also be required to keep the information required by subsection 3. Now, there is a definition for vehicles providing ride-hailing service, but not a vehicle providing public transport service. So, do we need to define the latter? Now, the nature of ride-hailing service is a private vehicle, which is deemed as a public transport vehicle when providing ride-hailing service, and there are additional conditions to comply with, for example, displaying the identification mark. So because of that unique nature, we think we need to clearly define when the private vehicle would become a ride-hailing vehicle. However, that's different for public transport vehicles. Now, according to the definition, public transport service means public transport services provided by vehicles other than private cars, for example, taxis. So they would not be used for personal use. So we don't think it is required to define what does it mean by a car providing public transport service. So we will specify clearly what type of information the platforms need to keep concerning this type of service. Now, the platform must maintain the record in a manner and formats required by the commissioner. So the legal advisor inquired about relevant examples and how often must the record be updated. Now, according to our reply, in order that the government can adequately monitor the compliance situation of the platforms, the Transport Department will establish an electronic channel and a platform to connect with the platform system. We will specify the formats and manner of the records to facilitate the collection of these information by the Transport Department. Now, there are a large number of information to be kept, so it is more appropriate to specify these details in the licensing conditions. Now, subsection 5, the licensee must store these data and ensure that these data are sent safely. Now, subsection 6, these are the definitions. Mr. Chao Siu-chung, thank you, Chairman. Now, this is a rather long provision, so please give me more time to ask my questions. First, section 12, subsection 2A, bracket 3, as well as B, bracket 3. These provisions mention the duration for which these information is to be kept. Now, 2A refers to the number of licensees' platform vehicles. Bracket B is about the number of working hours of the drivers. Now, in B, it says that the duration for which each of those drivers accesses the licensee's license platform. So B means the online time. So what about A? Does it mean the online hours of the online hours of the drivers, or does it mean the hours during which the drivers are carrying the passengers? It seems rather confusing. So when we require drivers to meet a certain minimum working hours, it is not fair to base that on the number of hours when the vehicles are carrying passengers. Some journeys are longer, some journeys are much shorter, so it's not fair. So please clarify these. And the government said that the platforms will be required to provide a rating function on their app. So I agree this is important. This is how we can assess the service quality of certain drivers. So why is the platform not required to provide the information on ratings of drivers to the government here? So I will leave my other questions till later. Mr. Kaib, thank you, Mr. Chow, for your questions. Allow me to clarify the difference between the two types of information we are requesting. Subsection 2A, bracket 3, that's the duration of service provided by each vehicle. That refers to the business hours of the vehicle when the vehicles are carrying passengers. Since there is an owner-driver requirement, the service hour of the vehicle is equivalent to the service hours provided by the drivers as well. Then why is it different with the provisions in subsection B? Now, like the legal advisors mentioned, the definition for the term access is actually the number of online hours. So that must be longer than the duration during which services are actually provided. So we would like to know how many drivers are online and for how long. What is the pattern? The other piece of information is about the actual hours during which the vehicles are providing a service. Let's say there are 10 bookings on a day, so we would like to know how long the journeys are in total. So A is targeting the vehicle and B is targeting the drivers. But it's not the case according to what you said. One is targeting the online hours and one is targeting the service hours. Why bother making it so complicated? Since there is an owner-driver requirement, you should just require two sets of data, that is online hours and service hours. Legal advisor. Thank you, Chairman. 12 brackets 2, 3 and B3. The wording here is access. In Chinese, 接達. I would like to draw to members' attention that the term access merely refers to the time when the driver has logged on to the platform. Now, if we use the layman term online hours, that may give the perception that the driver is ready to provide service. Now, by having access to the platform, it doesn't mean that the driver is ready to provide service. So I'm drawing members' attention to this point. Well, thank you. You're not requiring the information concerning the duration of which drivers are providing service, but rather you are asking for the duration of drivers' access to the platform. So you mean the actual hours of service provided by each driver. That's under 2A3. That's the information we are asking under 2A3. It says the duration for which each of those vehicles is in the course of providing ride-hailing passenger transport service. As we said, the service hours of each vehicle is equivalent to the driver's service hours. So when the vehicles are providing a service, it means the duration of the driver's service as well. So concerning access, it's about the online hours. Now a driver would log on to the platform and have access to the platform, and the clock would start. When accepting a booking, that would be another piece of information.
Chairman, according to the regulation, the driver need to declare when they're online, and the platform need to declare when the platform is accessible to drivers. Secretary. Let's go back to our policy considerations. There are two areas of regulation and monitoring. First, we need to monitor the performance of the platform. Under 12.2a, Mr. Chow's understanding is correct because there is a owner-driver requirement. When the vehicle offers ride-hailing service under 221, we ask the licensees to keep records in respect of the number of vehicles on the platform and the durations of hours of ride-hailing service offered. In B, is about the duration for which each of the drivers access the platform, because there is an owner driver requirement. By having this information, we know when or how long the drivers are online at the platform. This may not have a direct correlation with the number of journeys taken by the passengers or drivers, but that will be helpful for us when we assess the ecosystem. We want objective data from the platform so that we know how long the drivers are online and the distribution of online hours during the day. This will help us not just to monitor the platform's performance, but also make dynamic analysis. That's why in 12B, we ask the licensee to offer us records in respect of the duration for which each drivers access the platform. But there may be duplications, but we collect different data for different purposes. We will set out very clearly how the platform need to submit these information to us. Mr. Chao Xuecheng, I only had two questions. They have not addressed my question on ratings. The rating function. In section 12, 2D, the commissioner can ask the licensee to keep records of any other information specified in the license conditions. Through this sub-regulation, we can ask the licensees to keep records of driver's rating. So in the license conditions, you will ask the licensee to keep records of ratings of drivers. Is that correct? We can do that. I'm not asking if you can. I'm asking if you will. Yes, we will. Mr. Chris Yip. Records are required for platforms and drivers, but not passengers. I'm not asking the licensee to keep records of who take how many trips with the platforms. Can we not collect information on number of locals and non-local passengers taking ride-hailing service? Is it necessary for us to include such a requirement? Before we go into clause-by-clause examination, I ask the Secretary if they will assess the experience of non-locals taking ride-hailing service in Hong Kong on areas such as the waiting time, whether there is ride-hailing vehicles available. This is important when we want to improve the experience of passengers. Should we not ask the licensee to give you information on the types of passengers they take? say for example, the ratio between locals and non-local riders, so that there will be more objective figures for assessment. Secretary. When we scrutinize the clauses, I'd like to say that there is certain information we need the licensee to give us because we need to assess the performance and make dynamic analysis. In the regulation, we set out the information platforms are mandated to give us. Mr. Ip suggests that we need to collect information on whether a passenger is a tourist so that we can make analysis. We may not mandate the licensee to give us information on whether passengers is a local or not. We may, through other channels, collect these information and data. What information we need to collect so that we can have a more holistic analysis to improve the overall policy and service. We may not set that out in the regulation. And that is also why we have this subclause D. The commissioner can impose or ask the licensee to provide any other information specified in the license conditions. Mr. Chao Xiu-chong suggests some other information that the government may collect from the licensees, such as driver's ratings. We're not going to state categorically what type of information we are definitely going to collect and what data we are not going to collect from the platforms. We always want to keep an open mind. Mr. Lothar Lam, thank you. According to 12C6, the platforms need to keep records of traffic accidents. What accounts for traffic accidents? Does it have to involve loss of property or injuries? According to the regulation, this scenario is not set out that clearly, and how detailed should the information be? Bracket 2D, it is said that the platforms need to keep other information. Does the platform need to keep information on when the where the driver took the order? The trade worries that drivers will take street hailing, and after the passengers go on board, they make a booking, and the drivers then accept the order. Street hailing is only available to taxi drivers. But some people may see vehicles with identification marks, and they may go on board and just scan the QR code of the vehicle to make the booking with that particular driver. This may constitute street hailing. How can we combat that? Mr. Yip, thank you. Thank you for your questions and suggestions. We think that the licensee need to submit us with information on any traffic accidents because we want to have a more holistic grasp of the actual situation. We'll set out more details in the license conditions instead of in the regulation. There are different types of traffic accidents. Some accidents involve loss of lives or property. We'll clearly specify them in the license conditions. So that the licensees can share with us the relevant information according to our requirement. Should we not ask the licensees to keep records of where the driver took the booking? We'll consider it. We're now trying to regulate a whole new type of service. Will the operation of platforms change in the future? We are going to cater for that by setting out in the regulation that the commissioner can require the licensee to submit any other information specified in the license conditions. Mr. Chang Hofeng. Thank you. In 2C6, on insurance, you ask the licensees to submit information on any traffic accidents that the licensee's platform vehicles encounter in the course of providing transport service during the period specified in the license conditions. Why do you not ask the licensees to offer data for taxis that is registered with ride-hailing service platforms? This can help us in assessing the traffic accidents involving taxis and also ride-hailing service vehicles. Will the administration come to the LegCo about the data and statistics regularly? Second, in 2C, it is said that the licensees need to keep records of the amount of fares charged by licensees. Will you ask them to offer you more details? For ride-hailing taxis, ride-hailing private cars, after they complete the journeys, sometimes they don't understand the breakdown of the fares. Sometimes the drivers only earn 60% of the fares, and they don't understand why. I hope that the government will ask the licensees to also keep the breakdown of the fares charged by them for each of the journeys. The fares charged by the ride-hailing vehicles is different period in the day. I hope that you will ask them for the information as well, because there could be potential price fixing among different platforms. I hope that the government will also ask licensees to record the number of bookings rejected by drivers. I want to see if there are any unfavorable journeys not preferred by drivers, so that we can make a more holistic assessment. When passengers make a booking, when the drivers don't come, will the passenger continue to wait, or will they book a taxi instead? I think this is a very important piece of information for us. Mr. Yip. Thank you, Chairman. I thank Mr. Chong for his suggestions and questions. For public transport vehicles, if they're registered with ride-hailing platforms, we ask the licensees to also submit us with relevant information. In Section 12(3)(c)(6), it is said that the licensee need to submit us information on any traffic accidents that the licensee's platform vehicles, public vehicle encounter in the course of passenger service. This will help us in our feature analysis. We can assess the traffic accidents involving public vehicles and ride-hailing vehicles and make analysis. The members suggest us asking the licensees to record the breakdown of fares charged by them. We'll consider them. we may impose such a requirement in the license conditions. Thank you.
唔係因為咧，我見
In 2C bracket 6, you mentioned the licensee's platform vehicles brackets ride hailing. You didn't mention public transport vehicles. So does it cover both taxis and online ride-hailing vehicles? You said yes, traffic accidents information for both types of vehicles should be included. Well, that's under subsection 3. Yes, 12 subsection 3 up to C. The entire subsection 3 refers to other public transport vehicles and the requirements on record keeping for them. Now 3C bracket 6 also mentioned that the licensee's platform vehicles brackets public vehicle should also provide a traffic accidents information. Mr. Chen Siu-Hong. Thank you, Chairman. Section 12, subsection 2A, B, and C. Why do you have to break it down into 3 parts? The reason is the government is requiring a detailed breakdown of the information to be provided by platform. Now we always use the layman terms, online, offline, accepting a fare, and so on. So to alleviate Mr. Charles Siu-Chung's concern, maybe it is better to include them all in a single paragraph. Since we are requiring information from both the vehicle and driver, we need information for both. Now, the manner of online is different for different platforms, so there will be some uncertainties in the future. So I understand why these provisions are drafted like that. Subsection B refers to being online, but not necessarily accepting a fare. Now, we have spent a lot of time on defining the meaning of a period during which ride-hailing service is being provided. So Part A is clear. It's about that duration. Part B covers the time spent online before and after the journey. So I think these information is important for the purpose of detailed analysis by the government in the future. So despite the clumsy drafting of the provision, they are still necessary. So my second question is about fare. Now, Mr. Mark Chong also asked whether a breakdown has to be provided concerning the fare. The answer is yes. If you look at Section 6, there is a definition for fare. Fare includes the booking fee as well as any additional fee. So besides the term booking fee, there are other names for the same fee. There may also be incentive for drivers or passengers. For example, free first 5 trips or discounts for the first 5 trips. So in case any platforms make use of this loophole to lure passengers through massive discounts and outcompete other service providers, including taxis, we need this information. So in 12D, you reserve some flexibility by saying that you will require any other information specified in the license conditions, but it may cause confusion as to what types of information are included under other information. So I think you should spell out the particular types of information under Section 12, and also there should be clarification in the future practical guidelines. I have other questions as well. I will wait for my next turn. Mr. Kirk-Ip, thank you, Mr. Chen, for your suggestions. You're right concerning the online hours as well as the actual service hours. Mr. Chan's understanding is correct. Now about fare, we have a definition. Fares include both booking fees and additional fees. We intend to include these two types of charges to avoid any misunderstanding. Now, concerning any other information provided by the platform, we will give clearer explanation when we issue the license so that the platforms understand what types of information may be included. Dr. Thomas So. Thank you, Chairman. Now, all the information mentioned in Section 12, the keeping of these records are extremely important for the government's analysis on the performance of the platform. So Section 12 only refers to the obligation of keeping of records. Now, those data are dynamic on a daily or even hourly basis. However, this provision only requires keeping of records. Subsection 4, it says, keep the records in the form, in the way, and for the period specified in the license conditions. Subsection 5 says that the licensee must ensure the security of the transmission and storage of those data. So does the government have the authority to inspect the records? The data are dynamic every day. So does it mean that the platform only needs to send the data and store them in a platform and send them to you on request? Now it seems the requirement is only for the platform to keep record of each kilometer of the journey. So let's say if the journey is from Wan Chai to the airport. Now in theory, according to the requirements, the platform only needs to provide you with the length of the journey in kilometers, but rather the origin and the destination of the journey. So I wonder if the government would also obtain information in relation to where the journey starts and where it ends. It may be useful for the government in assessing the demand for point-to-point transport service in particular districts. That's my second question. Third question, the cars models. Now you only require information on the seating capacity. Now, as mentioned on the previous occasion, for infants to ride a vehicle, baby's car seats are needed. The same applies to wheelchair-bound passengers. So concerning the types of vehicles deployed for each journey, should the information be included as well? I think that would be useful for us to analyze the demand for those vehicles and what types of vehicles should we grant permits to. 3 questions, Mr. Kirk-Ip. Thank you, Dr. So. First of all, information stored in a platform. In the future, the TD's platform will be connected to the platform's database. So we will require specific formats of information. For example, the number of working hours of drivers. We may require, say, an update on a daily basis so that our system can verify those platforms, can verify whether those information has been obtained on a daily basis. Now, the information we obtain will include where the journey starts and ends, and also concerning the equipment or the fitting out of each vehicle, including seating capacity and also whether there are safety seats for infants and whether the vehicles are wheelchair passenger compatible. For these information, we may consider including them under other information to be obtained. Thank you. Mr. Charles Siu Chung. Thank you, Chairman. I have several simple questions. First of all, Section 12(2)(c), brackets 1, the number of platform bookings received, and also the number of such bookings cancelled. Now, has the government considered obtaining information on the party which initiated the cancellation, whether it is the driver or the passenger? Now, according to the regulation, you only require the number of bookings received or cancelled. Now, for other details, can you specify them on the licensing conditions to require information on which party cancelled the bookings? In 12(c), brackets 5, 12(2)(c)(5) on complaints. Will you request the platforms to keep records of their follow-up actions after complaints is received, and also the investigation conducted and evidence gathered? Are you only requesting the platforms to provide information on the number of complaints received and the time spent on responding to the complaints? I think you can obtain more information. Now, about accidents. Information about accidents are only required during the provision of service. However, you are not requiring the provision of accidents information when the drivers are online waiting for a booking. So can you also request such information for research purpose? Kirk? Thank you, Mr. Chow, for your questions. I thank Mr. Chow for being very particular concerning the types of information required. So we thank you for your suggestion. We will add a specific breakdown in the regulation to request for the additional information, whether it is the driver or the passenger who cancelled the booking. That will indeed help with our analysis. Concerning complaints, the regulation specifies that we can obtain information based on a certain frequency we required. So for complaints, say for example, we may require daily updates on drivers' information, but for complaint, we may give the platform give the platform more time to update the information. Now, once a booking is accepted, the private vehicles would become a public transport vehicle. So if a driver is online but has yet to receive a booking, indeed, the vehicle is still being used for a personal purpose. So the most important thing is that there is still insurance coverage for that period of time. So when there is a traffic accident, the insurer has to refer to the platform to see whether the driver is on the way to pick up a fare or whether the driver is waiting for a fare. Then there would be different insurance arrangements. Thank you.
講完。
多謝主席。主要關心幾個方面。
Thank you. About the data retention period. Just now, the secretary said that some data need to be updated every night. Some records are just to be kept. As far as I understand, data on the platform changes every minute. Will we ask the platforms to keep records in real time? Second, I wonder if the administration have power to verify information kept by platforms. Sometimes when passengers have complaints, they may lodge it to both the platforms and the government. What happens if the data kept by the platform is not the same as set out in the complaints sent to the government? Third, what about penalty? If the platform fails to keep records properly, will there be any consequences? There's none set out in the regulation. So is it the case that the commissioner, when they consider the renewal of the license, will consider this point? Should there not be any fixed penalty if the platforms fails to comply with the data retention requirement? On keeping of passenger complaint records, will the licensee keep records of whether the passenger is satisfied with the follow-up action of the complaint? There may be disputes over fares. Will we ask the licensees to keep records of the outcome of the negotiation? Thank you. We can set different time frame and frequency for data retention. For different types of data, say for example, the total number of complaints, we may collect such information from the licensees every month. For data related to vehicles, we may ask them to submit relevant data more frequently. As I said, the Transport Department will develop a system that is connected to the system of the platform. Through this platform, we will be able to collect data. We may compare data among different platforms to see if there is any particular platform having problems with the data. We may conduct a surprise inspection. We will check if the journey our colleagues take is duly reflected in the records of the platform. This is how we can verify the validity of the data kept by the platforms. On penalty, as mentioned by the secretary, we ask the platforms to maintain an effective service. If they don't comply with our license conditions in keeping the records, we can convene a hearing. We may fine the platform. If they contravene the conditions multiple times, we may increase the fine. The commissioner have the power to vary or suspend the license of the platforms. We're of the view that the consequence is clear and deterrent enough. During the day-to-day operation of the platform, we will keep in close communication with them. If there is any problems, we talk to them and ask for correction. Mr. Chang Ho-fong. Thank you, Chairman. 12C5 says that the licensee need to keep records of any complaints received by the licensees in respect of the bookings. And they need to ensure the security of transmission and storage of the data. The systems of the platform store much data of the members of the public, say for example their journeys, their positioning, and the credit card information. We have VIPs coming to Hong Kong. They may be senior officials from other governments. They may take ride-hailing service to government headquarters. The data involved may be of national security. Will the information stored in the servers of the platform be located in Hong Kong? Is there such a requirement for that? Thank you. Kirk? Thank you, Mr. Chong, for the comment. Privacy and data security are of utmost importance to us. We do have such relevant requirement in the regulation that the licensees must store the conditions in the manner specified in the license, and we ask the licensees to ensure the security of the data. We also have national security related clauses in the license. Platforms collect personal data of their passengers, and they need to abide by the Personal Data Privacy Ordinance. We're going to set out in the license conditions that the platforms can only use the relevant data for ride-hailing related services. When they need to use the personal data, they need to obtain consent from the owner of the data. If there is any form of non-compliance, according to CAP 46, we will invoke CAP 460, the Personal Data Privacy Ordinance. We hear many views regarding the locations of the servers storing personal data of the platforms. We'll look into how we can make sure that the data is stored securely and safely. Thank you. Mr. Chan Xiu-hong. Thank you, Chairman. We already covered the question put by Mr. Chang Ho-fong during a policy discussion. The Secretary undertook that they are going to include a national security clause in the license of the platforms. Last time, we discussed where the servers and data lockers should be located. The Secretary undertook that they will look into it. I understand that there are different requirements in different cities. We have to strike a balance. However, we need to have regards to national security as well as data privacy and security. We are worried that if a server is located in some other countries, say for example US, Europe, Southeast Asia, when there's geopolitical disputes, the server may stop offering service to the platforms, and the platforms may be forced to stop their operation, and that will affect people's commute. Second, on keeping of records, in 1245, it says out clearly the requirement for a potential platform operator from now to November next year, they may need time to make preparation for how they should keep the records. I hope that the government will clarify the format of record keeping and the relevant requirements when the platform ceases to operate, as well as the length of time the platform that has shut down need to keep the records for. I have one more question on transmission of data. Just now, Mr. Thomas Song gave us a very good suggestion. After the regulation comes into operation, the government will be able to collect real-time data from the market. Apart from point-to-point transport service data, it would be great if the platform can give the government data on which tunnels the drivers prefer. This is conducive to the formulation of traffic control measures of the government. This allows the government to know which trunk roads or tunnels are congested during which period of time. Apart from offering data on the journeys taken, maybe the licensees can offer government on the details of the journey taken. Thank you. Secretary. In the last meeting, when we talked about data security, I gave a rather comprehensive reply already. We have to uphold data security and national security. On the transmission and storage of data, we hope that they will be done in a manner that is safe. We've looked at our own needs and we have looked at the trends of ride-hailing service over the world. We want our license conditions to be strict. Second, on data related to routes taken, as Mr. Chen said, the amount of data involved is substantial. As we are going for smart city governance and smart traffic management, ride-hailing service is a great start for us because bookings are made via technology and online platforms. We do have a system for us to collect such information. As I said time and again, we just want to set out what is absolutely required in the regulation. For other suggestions made by members on what type of data, what type of more data we need to collect from the license so that we can make a more objective assessment of the traffic and transport system of our city, we may include that in the license conditions. We will try to collect more data and information so that we can formulate better traffic and transport related measures. Thank you.
Mr. Eric Yim, my questions have been covered by the previous members just now. I would like to talk about the duration during which the data is kept. Now, different platforms may keep the data for different durations. Some may refresh the data every half a year. Some may do so every year, just like the CCTV records in the LegCo complex building. So the validity period for the license is 5 years. So does it mean that during the specified period, that is 5 years, the platforms have to keep the records properly? Now in Hong Kong, it takes quite a long time if there is a litigation ongoing. So usually you would have to retrieve the records from 2 or 3 years back. So is there a unified standard on the duration for keeping records? Now concerning data in relation to personal data, that includes the log-on information from users' cell phones. Now sometimes you would receive a dozen notifications from the same platform to advertise their service. So is there any restriction on these advertising notifications? Secretary, thank you. Concerning the format, manner, and duration of record keeping, there are 3 guiding principles. There is information directly related to the commuting pattern, which require more frequent updates and transmission. And the duration of storage may also need to be longer. And also, the government will have to assess and analyze the data. There are different procedures including analysis and review. So the duration must be long enough for the departments to complete these processes, including a hearing. Thirdly, for law enforcement, evidence gathering and investigation is needed, and also a hearing date may have to be set, and there may be a validity period for the evidence. So under these 3 guiding principles, we will set the requirements for concerning how long these data has to be kept. Concerning advertisement using passengers' information, as we mentioned in the licensing condition, we will set out clearly that the information collected can only be used on the provision of online ride-hailing service. Now, according to the existing law, the platform must obtain consent from the passengers before they can use the information for marketing purpose. So that's usually in relation to the fair discount of online ride-hailing vehicles. There are usually notifications concerning the discounts available. So is that allowed if platform sends notification concerning discounts? If the information is in relation to the ride-hailing services provided by the platform, for example, when there are competition in the market, some platforms may issue discount vouchers to clients. We think it is also a reasonable use of personal data. Mr. Chen Pui-Leung. Thank you, Chairman. Now, a private car will be used for 2 different purposes. If it is a ride-hailing vehicle, so it is important to make a distinction between the 2 uses. Now, when a driver is online waiting for a booking, the vehicle is still a private car, so it would become a ride-hailing vehicle once the booking is accepted. But that would be a gray area. Let's say if I have my family members or friends in my car, at the same time I'm waiting for a booking on the platform. So when the booking is received, my family members or friends are still on the vehicle. So if I encounter an accident on the way, it would lead to a difficult situation. Since it is already a ride-hailing vehicle, then the original insurance will not be able to cover the accident. But because there are other passengers other than the legit passengers on the car, the ride-hailing platform's insurance package will also not cover the vehicle. So how should this situation be dealt with? It would lead to uncertainties in insurance coverage. Kirk? Thank you. That's the characteristic of a ride-hailing vehicle. Sometimes it is a private car and sometimes it is a ride-hailing vehicle. So we need to draw a distinct line on the transitioning from one capacity to the other. So we have had a very close discussion with the insurance sector. In the future, if only one insurer is involved and only one insurance policy is involved, it would prevent disputes. And also, we will have practical guidelines for the platform and drivers to follow. We will spell out clearly that if the driver plans to do business with the vehicle, then they should avoid using the car for personal uses like transporting their personal passengers when they are on the way to accept a fare. I think Mr. Chen Puilan's question is very important. We should prohibit this from happening. I'm more inclined to prohibit this practice. Once the identification marking is displayed and once a booking is received, the driver should not use the car to carry their family members or friends, otherwise it would be very chaotic. So there should be more clarification in the future in the written reply after the meeting as well. I'm also very concerned about the information collected. The information is mostly about the drivers or the vehicles themselves and also the operational data. But there is a lack of information collected on the passenger side. Now there is a concern if the platform make an advertent or inadvertent mistake, it may give rise to shadow demand, which would affect the accuracy of the data. Shadow passenger means that there are no passengers in reality, but on the surface, according to the data, there are a lot of demand which is not fulfilled. So in the process of data collection, will the governments be able to detect these shadow demand? It would be impossible to determine whether the passenger is real if we don't have information on the passenger. So will the governments pay extra attention to that to verify the data? Secretary. In the process of data collection, there will be a lot of unexpected scenarios. So we will bear in mind Mr. Chan's reminder and look at that together with the Digital Policy Office to prevent that from happening. We will come up with ways to verify the data. Not necessarily on every case, but we will conduct random inspection and verification. So this is more on the preventive side. We may not notify the platform in advance because that would be part of our law enforcement strategy. If there are no more questions, let's continue. Thank you, Chairman. We're now at Section 13 of the regulation. In the amendments bill last year, Section 55M1 has been added to the ordinance to empower the Commissioner to give direction concerning the license. Now, according to Section 13, if the Commissioner decides to issue directions, then the licensee must be notified in writing, and also the commencement date a specified date must be set, and the specified date must be later than the end of the period of 21 days beginning on the date which the notice is given. Mr. Chen Xiu-hong, thank you. I would like to seek clarification on the term direction and also variations upon consulting the licensees. Now, according to 55M1, the Commissioner may issue a direction to the service licensee. Now, the direction may be given to the licensee after consulting the licensee and based on the license. Now, Section 13 refers to Section 55M1 of the ordinance. Now, the scenario is that, does it mean this is a scenario where the Commissioner has consulted the licensee to vary some of the license conditions? Now, B1, B2, it says it must not be inconsistent with the license. Now, is the direction different from the direction issued to the licensee after consulting them to vary the license conditions? So it seems like the provisions are not very clear. Kirk? Thank you, Mr. Chen. Now, the two provisions deal with different scenarios. Now, Section 7 is in relation to variations imposed on the license by the Commissioner. These are more formal variations which must be in writing form and is subject to appeal through the Transport Tribunal. Now, for Section 13, the Commissioner may require the platforms to rectify or improve their services. So this may not have to do with the license conditions. So for requests for improvements, the Commissioner may do so through a written direction. But it must not be inconsistent with the original license conditions. If it is more appropriate to vary the license conditions, then we would invoke Section 7 to change the license conditions.
我理解都係相若嘅。
Chairman, in the Amendment Ordinance Section 55M(1), my understanding is that the directions will be set out in the regulations. But according to Section 13, It says a direction under Section 55M bracket 1 of the ordinance may be given to the ride-hailing service licensee either generally or in particular case. And there is a specified date in which the direction should be made. If my understanding is correct, I have no further questions. Understood. Please proceed. Now we're at Section 14 of the regulation. Inquiries conducted under Section 55N bracket 1 of the ordinance. If the licensee does not comply with license conditions, the commissioner can appoint a public officer to conduct an inquiry. And Regulation 14 is about the inquiry. The public officer need to set a date for the hearing, for the inquiry, and they must give written notice to the licensee about the date of the inquiry, and the public officer must consider any evidence received by the officer and the oral or written representations made by the licensee. Mr. Chao Chu-cheng. Thank you. I have questions regarding the procedure of the inquiry. 14 bracket 1b says an inquiry must be conducted at least 21 days before the inquiry takes place. Will we ask the public officer to set out the charge of the licensees in the written notice, or which license conditions have been contravened by the licensee? If the ride-hailing service platform licensees does not attend the hearing or inquiry, can the hearing be convened in their absence? If the licensee does not make oral written representations, do we need to postpone the inquiry, or should we proceed with the inquiry without the representations made? Lastly, can the licensee ask to postpone the inquiry? These are my questions. Kirk. Thank you, Mr. Chow, for the questions. This is about the inquiry arrangement. The purpose of the inquiry is set out in Section 55M of the ordinance. If the commissioner have reasons to believe that the licensee does not comply with the license conditions or about to contravene the license conditions or any other regulations, then the commissioner will be justified to conduct an inquiry. In the future, the Transport Department will keep in close communication with the platform. When we identify any problems, the Transport Department may just talk to them directly without conducting an inquiry. We may remind them or ask them to rectify some of the issues that they have. When it comes to an inquiry, the regulation sets out the relevant procedures. For example, when the licensee will be notified of the inquiry and the procedures. The licensees have the power to attend the inquiry, make oral or written representations. If they don't do that, then they are deemed to have given up their power, and we will conduct the inquiry in their absence. We will base our decision on the information that we have if the licensee does not make any oral or written representations. Will the inquiry still be conducted in the absence of the licensees? If they don't attend the inquiry, then we'll still convene the inquiry. I believe that the platforms are companies of scale and they have made certain investments, and I believe that they will be willing to address any issues raised by the Transport Department. I don't think that licensees would refuse to attend inquiry or make written or oral presentations. Secretary, we want to set out the procedures clearly in the regulations, just to be fair to the licensees. Just like any other licensed service, the commissioner have the power to conduct an inquiry. In the license conditions imposed on the licensee, we are going to state clearly the inquiry procedures, the time, the date, as well as the rules they have to abide by. We will make reference to the existing inquiry procedures with other licensing service so that ride-hailing service licensees understand the procedures that we have for existing inquiry. I believe that the Transport Department are experienced in conducting inquiry. Mr. Jonathan Lampert. Thank you. My question has been answered. Mr. Lothar Lam. Thank you, Chairman. Section 14 is about what public officer need to consider. That includes oral or written representations made by or on behalf of the licensee. Does that include the legal representative of the licensee? Second, if the public officer appointed thinks that there is certain information that will be useful for the inquiry, can they ask the platform to submit that relevant information? Because currently the public officer is not empowered to request additional information. Will that undermine the inquiry? If the licensees choose to not attend the inquiry, will there be any legal consequences? Kirk, thank you. Simply put, legal advisor or legal representative may make oral or written representations on behalf of the licensee. We conduct an inquiry to see if there is any contraventions. We set out very clearly if the licensee contravene any license conditions, they may be fined or may be subject to other penalties such as suspension or revocation of license. We believe that the platform will be motivated to explain the charges put by the administration. If they do not attend the inquiry, there may be consequences. So we believe that the licensees will be willing to attend the inquiry. Please proceed. We still have time left. Now we've come to part 3 of the regulation. It's about ride-hailing vehicle permits. From 15 to 28, there are 2 divisions. Division 1, ride-hailing vehicle permits. Section 15. According to Section 55T2 of the ordinance, the Commissioner may adopt a following method of selection in determining whether to grant the application to draw lots or make a selection if they receive more applications than the quotas available. The Commissioner may draw lots or make a selection among those valid applications according to the criteria specified by the Commissioner. They may accord priority to certain types of drivers or permits or vehicles when they grant the permits. Bracket 2 sets out the examples of criteria to be set out by the Commissioner, as well as the information that needed to be submitted by the applicant. One of the examples can be types of vehicles. If the government thinks that we need to promote certain types of vehicles. Say, for example, new energy vehicle to offer ride-hailing service, the commissioner may give priority to new energy vehicles, depending on the criteria set out in the invitation and the information submitted by the applicant. The commissioner may ask the applicants for further information. In the invitation and selection document, we're going to set out clearly the requirements. That's why we don't have to include that in the laws. Mr. Chan Xiu-hong. On different occasions, we've discussed this topic. This section is rather controversial. We all understand the drawing of lots. Some people are worried that full-time ride-hailing drivers will not be able to be allotted a quota, and the capacity of ride-hailing service may be undermined if we don't allocate 10,000 permits. Some people think that priority should be accorded to experienced ride-hailing drivers or taxi fleet drivers. Some drivers are providing now ride-hailing service illegally. If we accord priority to them, then that may not be fair. If they disclose the fact that they are already providing ride-hailing service, should the government prosecute them, or should they accord priority to them? That's a question. The secretary, the government said that they may accord priority to certain types of private cars, say, for example, clean energy vehicles. I think that the commissioner need to state clearly which types of vehicle would be accorded priority before the drawing of lots happen. What's the plan? Second, will the commissioner set out the same set of criteria for all rounds of drawing of lots? I think that the administration should have some ideas in mind. Can you share with us what considerations you have or what criteria you have in mind? Thank you. Thank you, Mr. Chan, for the questions. We try to set out all possible method of selection in the regulation. When the commissioner invites for application of vehicle permits, a notice will be published. I can share with members our plan. First, given the limited number of vehicle permits to be allocated, we try our best to invite interested ride-hailing vehicle owners who are also the drivers to make applications in an open and fair manner. That's our first consideration. Second, we don't want anyone to try their luck in submitting their applications. This may increase the burden on our road system without increasing the ride-hailing capacity on the market. And that is why we may accord priority to certain description of persons or private cars. For people who have owned the private cars for a certain period of time, say for example 1 year or 2 years, we may accord priority to them so that they have a higher chance of being selected or being allocated a vehicle permit. Secretary, I have to extend the meeting by 15 minutes. Thank you.
Please continue. Some also mentioned the possibility that there are drivers who are providing services with their own private cars. At present, we emphasize that it is illegal to provide these services at present. These are illegal passenger carrying service. So we will consider giving priority to existing drivers. So in policy, from a policy angle, we should not encourage these practices. First of all, these are illegal services. And also, there is no way to verify the data or information provided by those applicants, so it would not be fair. Now, the intention is good, but it is difficult to achieve from a practical point of view. So having struck a balance, we consider our existing approach is more fair and simpler and easier for everyone. In any event, in the future, when the Commissioner extends invitations to apply for vehicle permits, there will be a notice clarifying the selection method. Please rest assured there will be clear information for the market. Mr. Jonathan Lampert. Thank you. Now, 15.1 specified categories of private cars. Now, there is only 10,000 permits, and the competition would be keen. So different platforms with different types of vehicles in service would make different profits. Now, the idea is to make the service safe, efficient, as well as affordable. So among the 10,000 permits, will there be a proportion set for lower priced or new energy vehicles that will encourage drivers to use affordable as well as environmentally friendly vehicles, but rather luxurious vehicles? Secretary, in short, the regulation allows us to specify certain types of private cars. So in consideration of our policies as well as the affordability of passengers, and to ensure a more diverse range of options which are safe and environmentally friendly, we may specify the number of a certain type of vehicles among the permits. Mr. Mark Chong. Thank you, Chairman. I thank the governments for taking on board our views, including not according priority to existing drivers providing illegal passenger carrying services. We should not endorse that. Now, in the future, there should be a ratio set for, say, 5-seaters or 7-seaters electric cars, according to the market demand in the lot drawing process. So I would also like to suggest another type of vehicle. Just last Wednesday in the Council, we mentioned the issue of bus safety. Those vehicles are equipped with DMS or ADS, driver monitoring system. So we should accord priority to private cars installed with DMS devices. We will consider the suggestion carefully. Ms. Lam Wai Kwong, I thank the Secretary for stating clearly that the government will not consider according priority to drivers who have provided illegal passenger carrying services in the past. It is black and white. Now 15(1)(a) Part A says that the drivers must have a ride-hailing vehicle permit. So does it mean that on applying the license, they do not need the vehicle permits first? So does it mean that the driver can apply for the vehicle permits before he has passed the examination? Now, brackets 3A, the condition that the driver must be a person with the driver's permit, we haven't included that in the regulation because on applying for the license, the driver may not have passed the examination yet. So after granting the permit, there is a period for the driver to pass the examination, so that when the official permit is issued, the driver would have already passed the examination. Only then would an official permit be issued. So in other words, when drawing lots, the driver may not have a date for the examination, but after the permit is granted, or after the lot is drawn, the driver will have some time to pass the examination and prove to us that he has already passed the examination before we grant him the license. And on renewal, the driver has to prove that he is still eligible for the permit. Now, you haven't specified the 2 specified days. If I win the lot but I haven't got a pass in the examination yet, what should I do? And if a vehicle permit is granted to my vehicle, but you have yet to verify my owner-driver identity, what will happen? Now, on applying for the lot, it is possible that the drivers have not been given a date for the examination yet. So we will state clearly on notifying the applicants of the results that a lot has been drawn in your favor, and please supplement all the information during the specified time period. That would include the driver's license or driver's permit. Secretary, I would like to clarify on this point. Now, on owner driver, this is our policy and there will be a way for us to verify it. So in the future, both the vehicle and the driver must have a permit. So I thank Mr. Lam for raising this particular question. As mentioned by Mr. Kurt Ip, there are different procedures, including sending out invitation to apply for the license, as well as arranging for examinations. So in the future, permit allocation exercise, if a lot is drawn in someone's favor, we will ask the person to supplement the driver's permit after passing the examination. So there will be a timetable issued in the future concerning the lot to be drawn as well as the examination date. We have had some internal discussion on the arrangements already. Mr. Eric Yim. Thank you, Chairman. At present, taxi drivers must have obtained a driving license for more than a year. Now for online ride-hailing vehicles, a driver can apply for the vehicle permit even though they have just newly passed the driving examination. Now, if we allow new drivers to drive online ride-hailing vehicles, it would lead to risks. So would you consider aligning that to the taxi trade, so that only drivers who have been driving for a certain period of time can apply for the permits? I believe that's about the driver's permits, but rather the driving license. Yes, we understand Mr. Eric Yim's question. When we come to Part 5, there are a series of conditions to be met to obtain a driver's permit. That's like taxi driver's eligibility. That is, the driver must be 21 years old or above. They must have obtained the driving license for at least a year when applying for the license or the permit. Now bear in mind that there is a limited number of vehicles permits, that's 10,000. Drivers who would like to draw a lot for the vehicle permits as well as apply for a license, the number may be overwhelming. Now the Transport Department will arrange for sending out the invitation and arranging for examination. Now when permits are granted and when the drivers provide the service, both the vehicle and drivers must have obtained a license. The requirement is clear. There will not be a case where the vehicle is legal but the driver has yet to obtain a permit. It's about time. We will stop here. Concerning the submissions, please note that we have conveyed all the written submissions received to the administration for written reply. After receiving the government's reply, the Secretariat will circulate the replies with members. Now we will set a date for the next hearing, for the next meeting, and you'll be notified in due course. Thank you.